Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I am here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments and I will answer your questions. I have a great topic for you. So, I'm going to talk about an option available to citizens of certain countries that would allow you to come to the United States and be able to build your business here, expand your business in the US. You could also bring your family here. Now, this is an option that not a lot of people know about. So I want to bring it to your attention and let you know that I am here to assist you to gain that status or that visa in the United States. It's called the E2 Treaty Investor Visa. And it basically allows you to come to the United States to start your business or to expand your business. So if you're already a business owner in your country and you really have some strategic plans to move your business to other countries like the United States, then guess what? That the visa is going to be perfect for you. This visa, though, the catch here is that it is only for certain individuals, of citizens of certain countries. And now these countries here, for example, on the western side, these are countries all across the world. However, I'm going to list it. I could spend the entire time listing the countries out because there are so many. However, let me list a few, and then it will be up to you to schedule the consultation to see if you qualify. You can also look online at the USCIS.gov's website. You could click and type in the search E2 countries, and you will see the chart pop up with all the countries. But the countries are going to be included on this side of the world, the western side of the world. It's going to be Canada, Jamaica, Grenada, Trinidad, Mexico, Costa Rica, Panama. It also includes Argentina in South America. So these are some of the countries, and I think I may have said it, but Trinidad, it also falls under one of these countries, qualifies as one of these E2 treaty investor countries. So if you're a citizen of one of these countries, these are just examples. There is an extensive list. For example, in Europe, it also includes England and other European countries. If you are a citizen and you can show that you have or you are currently investing a substantial amount to successfully operate your business here in the US, then that E2 treaty investor visa could be yours in a couple of months. And then keep in mind that your family, your spouse and your children who are under 21 and unmarried can come along with you on as a status. They would have the ability, spouses of E2 treaty investor holders, visa holders. Now, once they enter under the E status, they can automatically work. They don't have to wait for to apply for employment authorization to get the work permit. So that is also an added benefit. Also, the spouse does not have to show that they are the citizens of the E2 countries. So, for example, if you're Jamaican but your spouse is from Guyana, you don't have to show that your spouse has anyway become Jamaican or is a Jamaican citizen to qualify for this. The only person that needs to qualify for this would be you and your business. Now, let's talk about the business side of it. What if you have a business, but you have a partnership with other people? You need to show that this business that you're going to grow in the United States is at least 50% owned by you or an individual, whoever is applying for the E2 treaty investor visa. It has to be 50% owned. That company has to be 50% owned to qualify for it. So you cannot be a minority owner in a business and get the E2 treaty investor to grow it in the United States, because they're not going to consider it a business that is of the E2 country nationality. Now, Once we have determined that you are a citizen, you do have goals to come here and grow your business, see, even start a business. You don't have to already be a business owner. You could have the intentions to start your business. The next thing we'll be looking at is whether you have, how much have you been investing in getting your business started, and how much do you need to continue to invest to get qualify for this. Now, you don't need millions of dollars right off the bat. If the company requires millions of dollars, then you do have to show that you have or you're currently investing those dollars. But the other is that if your company isn't going to take much to get up and running, it could possibly be that the high five figures could qualify you for this, but it depends on the business. There is no limitation on the type of business unless it's a type of business where you are not needed to actively grow the business here or run the business here or operate the business here. Then that could be a problem to get the E2 visa. And then also if that business has anything to do with passive. So say you have an LLC, you are the sole owner, and that LLC has rental property. If you're not actively running the business, so there's no need for you to be on site, there's no need for you to be actively running the property and operations and employees, and then it is going to be considered passive because you're just bringing in the rental money, and that does not count. Investing in stocks does not count. So this is where you have to show that whatever business you are running, it has to be a business where you have to be here to operate it, and that you have to be putting in the work in order, that you have to be participating in the operations of the business to be able to get this visa. Now, after we determine that you qualify for this, the next thing is to actually get started on the application process, and that's going to depend on what your goals are. So you could either stay here if you're here on a B2. So if you're here without status, unfortunately, the change of status is not going to work for you. You have to be in status. So say you're here on the B2, and then afterwards you decide that after a while of being here, you decide, I'm going to move forward with growing my business. And maybe it makes sense for you to stay here and do that through change of status. But it's tricky because change of status, when you change status, it means that you may not be able to travel. Actually, once you leave the country on an E2 status, you can't come back in with it. You'd have to go back and get the visa. So maybe getting the visa from the start would be the best option. And this is what I help my clients with from beginning to end. I help my clients to first determine whether they qualify in every way and how to make sure that they gather the right evidence to show that they qualify, and then the best ways to qualify. And then I represent my clients through the entire process and provide them the support that they need to make this a very good, thorough application. So if you're interested in pursuing the E2 Treaty Investor Visa, it is for individuals who are citizens of certain countries like Jamaica, Grenada, Trinidad, Mexico, Panama, Costa Rica, Canada, England, Argentina. So if you're if you're a citizen of one of these countries and you want to start a business or expand your business here, this could be for you, and it would allow you to carry your family here. Now, there is one thing I want to note is the disadvantage here is you grow a business here, but it is not a direct path to permanent residence. It could mean that you develop your business to the point where you can qualify for other types of employment-based green cards, but it does not, in itself, having an E2 Treaty Investor Visa does not in itself qualify you for a path to permanent residence or citizenship. But you may be able to use it as a vehicle to grow, develop yourself, develop your achievements to qualify for other types of immigrant permanent residents. So that's one thing. And also, it is a non-immigrant visa, which means that you still do have to show that you have the intention to go back to your home country, that your intention is to build a business here and it is not to stay permanently. So you still do have to show non-immigrant intent. That involves showing that you have maintained strong ties in your country. All right. Oh, it's so nice to see you, Waihuri, and thank you so much for tuning in. I appreciate it. Go ahead, ask your questions. Now I see questions coming in, and I am going to go ahead and answer. Oops, let's see. Okay, almost 41 days waiting for a decision on my RFE I-485. How long is the normal process for review? So it could vary, and it depends on what's going on in your case. So it could vary from a week to even months, and I've even seen over a year. So it depends. Pamela, if you have any concerns, you should definitely get legal advice. RFEs are all different. Now, RFEs, for those of you who are listening, it's a request for evidence. And it could vary from something simple like, we would like you to send in the affidavit of support. You forgot to sign a document. We want you to send the marriage certificate, to more complex issues. Maybe they don't believe that you qualify and you have to argue why you qualify. So Waihuri, absolutely, I'm answering questions. Go ahead and put those questions in the comments. I'm keeping an eye on those comments. So put the questions in the comments and I will answer. Last year, when I went to the US on a B1, B2, I stayed. Okay, so I'm not seeing the rest of your comments. So go ahead and put those in. Can I renew my conditional permanent resident card if my husband is not there? Ashley, absolutely. This is what I help my clients with. Now, there are specific ways to qualify, and you have to qualify either through divorce, through mistreatment by that spouse, or through your extreme hardship, and then formally apply for a waiver. So Ashley, go ahead, give us a call, schedule a consultation. We'll talk about your particular circumstances. And then if you qualify, we will then go ahead and get started on your case. So what I want you to know is there is absolutely a way to apply by yourself, but you have to understand what the requirements are and make sure you get help. As a matter of fact, they announced that they are now waiving interviews for applications that they believe are strong and clear and that they don't have any questions about. So 3, 2, 1, let's see. So 3, 2, 1, I don't remember. I get so many questions. Just go ahead and put your questions in the comments. Hi there. I have a B1, B2 interview next month. I'm self-employed. Any tips on how to go about it? So I'm not your attorney. I don't know what you have, but usually just bring anything that's going to show that you have strong commitments and ties to your country. So that's going to be your property. It's going to be your, proof of your business that you own or your self-employment, your bank statement showing how much income you make, letters from, clients. If you have evidence of future commitments that you have to return to, your children, that your children are there, or your spouse is there. So those would be examples of good evidence that you could take with you to show other assets that you may have in your country. I applied for VAWA complete package January 8th, no prima facie yet. Is that normal? So I don't know what your case is, so I wouldn't be able to tell you. Prima facies can take anywhere from 3 months to even more than that. So it's going to depend on what if they reviewed it, if they have any further questions. Usually by now you should at least get a request for evidence if they feel something is missing from your case. I-86 and by January, not necessarily. It's not unusual to wait 4 months. I've waited about 6 months to get the prima facie. So 3 to 6 months. So go ahead and make sure that you, in this case, you have to just check on the status. As an attorney, I have access to be able to communicate with the VAWA unit by email. However, you would have to submit a request in writing to get the processing times or information about the status of your case. The I-864, that was what they asked for. Okay, so the I-864. So Pamela, when it comes down to the I-864, they don't usually reply to that because if they've already received all they need, they will just keep processing your case. The only way you're in your case, what they will do is if they are still missing something, they may send back another request for evidence or even a denial. And so I often say in this case with the I-864, I'm not usually concerned when I don't hear anything. As a matter of fact, you're just probably going to get the work permit next, or you're going to actually get your interview next. So, while you have to keep an eye on your case, I wouldn't be too concerned. Oh, thanks so much, Ricky, for sharing the live. I appreciate it. So nothing, Natalia, nothing about individuals who are filing. So nothing, there's nothing going on. So let's see, a truck driver gets waived in by BP through an entry port coming back from Laredo. Can he adjust status AOS with an approved I-130 saying he got waived by Border Patrol? So your case is complex, and Waihuri, it is possible. I would have to understand exactly what your situation is. And with representation, because it is a complex matter, you're not just going to have you'd have to show evidence of that, of being waived in, and they would have to accept that evidence as credible and true to be able to give you the adjustment of status. But I also would like to know what else is going on in your case. Absolutely. So, Deet Meek, definitely go ahead, put your questions in. I'm here to answer questions. So put those questions in the comments right away so I can answer. They sent RFE for my I-130, but they suggest things I already sent in, like bank account. So is that they need new ones because almost married for 2 years? I'm not sure. I wouldn't be able to advise on what exactly they mean in your case because I'm not the attorney. I've never seen your case. So if you need assistance, I suggest you get representation at this point to properly respond to that request for evidence. You can go to the link in the profile. It will take you to the website where you can schedule the appointment with me and we can talk more about what the situation is in your case, and then go from there. But usually in the case where you get a request for evidence like that, it sounds like a joint bank account, then that means they probably have questions about whether your marriage is real. So you want to make sure you're careful about that. Okay, so I had a pending I-130 that got converted to the I-360 when my husband died. My son's case was closed and added on to me. I would like to know what to do next for myself and son. So I wouldn't be able to advise you on what to do. Now, usually if you have an I-485 already, usually it's just a matter of waiting. So waiting on a decision. Also, I don't know if you're here or if you're in another country, but if you're in another country, what would happen is they're gonna make a decision on the I-360. And then after that, you would go through the National Visa Center to get your case processed and to be able to get the immigrant visa to come to the US. If you're here in the US, my next question would be, do you have an adjustment of status application? Because that would allow you to stay here, get your work permit, and then attend the interview here in the US. So that is where I would have to understand what's going on to be able to advise further. You can always go to the link in the About, on the About tab on the YouTube, and it's going to take you to the website. There's a phone number on the website. And I can go ahead and put it here. So I'm gonna put it, okay, so you are in the US. So if you're in the US, then adjustment of status could also be a possibility. If the I-360 has been approved, then and your spouse was the US citizen, of course, then it would be the adjustment of status process. But keep in mind that don't act on any information here that I'm saying until you get personalized legal advice. The reason being, I don't know your history, and you should really make sure that you understand what's going on, whether you qualify fully for adjustment of status or how you have to go about it. But generally, if you have an approved I-360, the next step would be to work towards getting the green card through adjustment of status. If you're here in the US, you may have had it maybe it has already been sent to the National Visa Center, and at that point, you would have to make sure that your case is processed here in the US. And at this point, you have to be very careful. Don't leave the US. Don't do anything until you get that legal advice. My website is, I put it in the comments, so you can always pull it from there and go to the website and get the contact information. It will lead to the scheduling coordinator who can assist you. All right, so let's see. I see I-765 and I-485 fingerprints done in October 2021. It's been 6 months, but I haven't received an EAD card. So you are not alone on that. You can always get in touch with them and ask them to expedite your case and provide the evidence. So usually if it's either over processing times, which it is not, but if you have an issue that you need that work permit, you can always express it to them. For example, you have an urgent humanitarian need, there's someone or a company is going to face severe economic loss. If the delay is caused because maybe the USCIS made some mistakes, if you are a healthcare worker or you are a child care worker, these are also the basis to get an expedited work permit. So keep that one in mind. So when I get an idea of investment visa, can it be applied when you're outside of the US? Absolutely. Most people apply outside of the US, and it makes sense in most cases to apply outside of the US. So if you cross the border illegally and seek asylum, if you get married, can you get a green card? It may be possible. But if you cross the border without permission, then you applied for asylum, then there are a number of things going on here, right? If you're applying through the marriage base, then you're not admissible because you crossed the border without permission and possibly stayed over the time. While asylum, they may be willing to forgive that. If you're going to go through the marriage-based process, you're not going to qualify for adjustment of status, because adjustment of status qualifies for those who are immediate relatives of U.S. citizens and they came into the country with permission. If you came in unlawfully, it's probably going to be a more complex process. So, and I notice so just make sure that if you know somebody who's going through this, it is definitely something an attorney has to handle. Okay, so where is your office? Great question. I'm based in Boca Raton, Florida, but my practice is national. I represent clients all over the country. And so we work with USCIS offices, immigration courts all over the country, and we also work with US embassies all over the world. So no matter where you are, I can advise you and represent you. And we do phone and video consultations for those of you who cannot see me in person. And how much do you charge for the initial consultation? It's $150 for up to an hour. And this is where I evaluate all your circumstances to determine whether you qualify and then move forward. So you get the advice you need to make decisions, to understand your process, and to avoid mistakes. Yes, that's what they're questioning. So they're questioning if my marriage is real, but I sent in Lee's joint. So Quintel, don't gamble. At this point, don't gamble with your future here with your spouse. Get legal advice and representation. I am seeing a pattern where real couples are being denied because they submitted an application that just wasn't complete enough, and it painted a whole other picture for the officers, and many of them get into a lot of trouble, a lot of unnecessary complications. So Kuntel, make sure you get the legal advice and representation. I'm here to assist with that. What's going on with the USCIS? I did my biometrics March 7th, no answer, nothing. So they don't, after the biometrics, they don't usually send anything. If you go to your case status, you will see that sometimes they update your fingerprints. Sometimes they don't even do that. So keep up on your case. Call if you have any concerns. Travel document, can you explain about if you can use it? So the travel document is something that you should not, you shouldn't just take it for granted, right? There are some inherent risk with this travel document. If you're here, if your case, for example, they have complications, you have a couple violations, maybe you have a criminal background. This is the kind of situation where I'm very hesitant to advise someone to get up and travel. However, if their cases, they don't have their background, they don't have any of these complicated issues, at that point, I may tell the client they always face the risk, but they can travel. So I usually advise on a case-by-case basis. As I'm representing my clients, I advise them each on an individual basis, and I ask that they tell me whether they're going to travel, so I can make sure that it is advisable. When I say advisable with the risk to travel, right? Because they're always going to be the risk. You don't have official immigration status. So coming in, if the officer finds anything that justifies keeping you out of the country, they may just do that. So it's going to depend. Also, keep in mind that a travel document does not give you the privilege of traveling to another country without a visa. So if you want to visit another country, but you need a visa, you'll have to separately apply for a visa. I sent expedite request to Vermont a month ago, no response. So Anita, that's not uncommon either, especially if you do it in writing. So with me, I don't know what type of case you have, but when it comes on to the Vermont Center, I usually, there are other ways to communicate that you need an expedite. Is usually through the email, but this is only for attorneys. So biometrics we use for I-485, how long to get the EAD and advanced parole. So I wouldn't be able to, it's all over the place. And you sound Jamaican if your homeland is where the heart is. Yep, I am Jamaican. Yep, absolutely. So I'm not in New York, but as I said before, I represent clients in all 50 states. So no matter where you are, we're very experienced with representing our clients. We do have clients in New York, and we are helping them. We're working with them. We're effectively representing them. But I am based in Boca Raton, Florida, but we run a national practice. So it's an I-485 under follow-up. So yes, Anita, unfortunately, if you're unrepresented, you have to do everything in writing. And when you do everything in writing, it tends to be longer. It has to go through the mail room. It has to go through additional processing. That's the benefit too of having representation, is that as the attorney, while we can never guarantee results, we can never say because I'm an attorney, I'm going to get you an approval. What benefit you do have is for your attorney to take care of communications, and there are communication lines that are available to attorneys to communicate directly with officers regarding cases. So in this case, I know you had to do it in writing because they don't accept phone calls, and that can be frustrating and long. So no money to work, exactly. So Anita, I understand, that I definitely understand your struggles there. And it's frustrating because the VAWA is there to provide immigration relief to victims of abuse. But work permits are taking long across the board. And if you did it in writing, it's going to take a month. But because you did it in writing, it's probably going to take longer. How long will the processing time take if you marry a green card holder? So it's on the same timeline as marrying a U.S. citizen right now. But also, how are you at the embassy? Are you outside? Are you in the U.S.? That's going to also dictate how long it's going to take. Hi there, Edwin. Nice to see you. Greetings in Guyana. Which of the forms you use to do a 2-year green card, and what's the cost for the filing fee? So it is the I-751, and it's $680, I believe, to go ahead and file. So don't use that I-90 if you're gonna go from the 2-year to the 10-year. All right, so I say, so how much do you charge? Since you're from Miami, so no, Hury, we do have translators available for those. So we have Spanish translators and Creole translators for those who need translators. So you can always call. What is the cost of the adjustment of status? So it's gonna depend on what kind of case you have, but you can always call, schedule an appointment, and we can talk. So I'm going to head on over to Instagram. We're not finished yet. Join me on Instagram where we can continue to have this conversation. I'm the immigration attorney on Instagram. You can follow me there. I also release a lot of the videos on Instagram. So join me on Instagram in a quick minute, and then we can talk. If you can't join me, guess what? You can always join me tomorrow at 4 p.m. Eastern time, where we can continue to have a great conversation. Thank you for all your questions. These were relevant questions today. I'll see you in a minute on Instagram, or hopefully I will see you in a consultation. Just go to the link in the profile and we can go ahead, schedule an appointment, and then we can talk about your case and getting help for you. Have a great evening. Bye-bye.